I wanted to come here on to conduct this live stream based upon a comment from a viewer who was critiquing what it is that I said with regards to those with prior felony or certain misdemeanor convictions having a legal right to own under current federal and some state laws antique firearms. Primarily because under our jurisprudence, antique firearms are not legally defined as firearms, which is what many people would consider to be the loophole with regards to individuals with prior felony and certain misdemeanor convictions being able to, what people claim, legally own or possess those specific type of weapons. I've been racking my brain recently, because as an individual who has studied law for over 20 years of my life, I am constantly attempting to figure out why people feel and think the way that they do about the issue of us keeping and bearing arms. And I came to the conclusion recently that the problem here in America with regards to that issue is technically not members of Congress or some state legislator within the General Assembly or some governor who issues executive orders or some judge, whether that judge be a member of the federal judiciary or a state judiciary. It falls back on civilians, us civilians or citizens in general. And I say that because it appears to me that many of us have forgotten that we live under a democratic nation, which essentially entails that we are up under a government that was created by the people, of the people, and for the people, which signifies that we as individuals on a collective basis have far more authority than those in civil service do. So those whom we have elected or appointed to positions of public trust through the electoral process, they have a constitutional responsibility to us to protect and defend that document and all the other documents associated with it from enemy or foreign and, of course, domestic. But they have utterly failed in that endeavor. So what I realize is that people do not know what their true authority in this country really is. And that's because those in civil service have declined to educate or inform every civilian in this nation of their sovereign authority. Appreciate it. And because of that, so many people have gone through life in this country ignorant to law and politics, the very things that we all are governed by, although certain law and politics have not been enforced equally across the board to the extent that they were initially designed to be. But that doesn't mean that we don't have freedoms. That doesn't mean that we do not have a legal right to keep and bear arms under the Second Amendment. We have that freedom. It's just that we, the people in general, not myself, I'm excluded, but we, the people in general, okay, Mary, have allowed our civil service in public office to usurp their previous authority in which we have given them when they have created these laws, rules, policies, ordinances, executive orders that infringe upon the very freedom that we have that was designed to protect every other freedom. And of course, that right or freedom is the right that we have to keep and bear arms under the Bill of Rights. So one of the guys here on YouTube who goes by the name of, and let me make sure I get this right, at sour underscore OG underscore Chim underscore 420. He responded to one of the videos that I published on July 18, 2024 here on YouTube, where I was describing or informing people that people with prior felony misdemeanor convictions do actually have a right under current federal and state law to own specific firearms. And those firearms being what they have legally determined to be antique firearms. The definition of an antique firearm is any firearm that was made or manufactured prior to the year of 1899. A firearm can be made after the year of 1898 if it is a replica of an original antique firearm that was manufactured prior to the year of 1899. So we know that certain companies like Taylor's, they make Taylor's, Uberti, Pieta, they create replicas of original antique firearms. So it is lawful for an individual to have that firearm a replica as well. The only difference between an original antique and a replica antique firearm under federal statute and many other statutes, specifically here in the state of North Carolina where I reside, is that if a replica doesn't fire fixed or conventional centerfire ammunition, or let me rephrase that. If it doesn't fire rim or conventional centerfire fixed ammunition. Now, the key word in that particular statement under that particular law is conventional. Now, if you look up conventional in the dictionary, it specifically says that if it's not readily available, if you just can't get that ammunition anywhere. And from my experience dealing with antique firearms, ammunition for those particular weapons are not going to be easily found in any gun store. Oftentimes they have to be specially ordered, or you have to really just focus on one dealer that specializes in that type of ammunition or weapons. So, in addition to that, during the course of my legal studies, I found a case known as United States versus Royal out of the United States Court of Appeals for the Fourth Circuit. Trying to get everything together so I can actually quote it to you all. Okay, now in that particular case, a guy with a prior felony conviction was actually charged with the offense of possession of a firearm in commerce after felony conviction under statute title 18 United States Code section 921G1. No, let me take that back, 922G1. 921 is the definition of certain words under that specific statutory provision. But he was charged with that. But the judge threw out the gun charge because it was an antique firearm, but they kept the possession of ammunition after a felony conviction because they were under the impression that the ammunition that was in the gun was not considered antique. He had, I believe, what do you have in there? 9mm or something. It baffles me as to what type of antique firearm he had that can chamber 9mm rounds, but I have yet to figure that out. But anyway, so he was charged with that and ultimately convicted for having ammunition. But in his appeal, the judges did say that if his attorney had raised the issue that he presented on direct appeal, their decision on the ammunition may have been different. But because he did not raise that issue, because his attorney didn't raise it, they said that the claim was barred from being raised again, meaning if an issue is not presented in the lower court in front of a member of the judiciary, the appeals court judges claim that they are unable to hear that case because that particular issue was not presented in the lower court phase to where it gave them the jurisdiction to hear it at the higher court stage. I understand that, but under those particular circumstances, I disagree because we shouldn't be held accountable for the faults of an attorney who has misrepresented us in a specific legal matter. That should be all on that attorney. If that attorney didn't present an adequate defense based upon the legal knowledge that he or she possessed, the defendant should not be liable for the attorney's mistakes. And there's actual judicial precedent that actually supports that. But I don't think that brother knew about that particular case because he didn't present it. And if he did present it, the judges didn't mention it in their opinion. But the judges were saying this. If now where the heck is my paperwork at? I just had it. Y'all bear with me for a second. I know I got that over here. Because I just responded to that guy on YouTube. Yeah, I just happened to get on here, y'all, because I felt this was a matter of public importance, because every time I make a heartfelt attempt to educate members of society of the freedoms that we have, there's always some idiot that comes on social media attempting to troll, attempting to not take things as seriously as they were meant to be taken. And because of that, I can understand why there's so many injustices going on here in America as I speak, when it pertains to how we as civilians are being treated by our civil service and public office. There's a reason for that. And if we're just getting on social media just to troll people, just to play games, just to get views or subscribers, that's not going to cut it. It's not going to help everybody. Now, it might help the content creator, because the more subscribers they get, the more financial income that they generate, from what I've heard here on YouTube. So it might benefit them and their families, but how is it what they're doing benefiting us as a whole? It doesn't. Now, I would love nothing more than to come on YouTube and present specific arguments, and I will eventually get to that. And I know I've been saying that for a while now and haven't done it to the extent that I want to, but it's only because I'm busy doing other things right now that has set precedence over this, such as I'm doing a civil suit for a friend of mine who was hurt in the Federal Bureau of Prisons on account of staff negligence. That, in my view, takes precedence over this, but not as much. Meaning, I would like to be organized. I would like to show these cases to you all that I'm making reference to, because I know that many people tend to believe something more than they would if they just hear about it. Now, of course, I can cite judicial precedent, which is what I have been doing on YouTube and other social media sites that I associated with, to give people the citation numbers to where they can easily punch it up on Google. And the case will come up. They go into the case, they go to the page number that I specifically cited, and it will take a person directly to the quote that I made reference to. I'm making it easy for everybody to understand with the time that I have to do it. So, but anyway, for some reason I cannot find what I'm looking for, but I'm gonna go and just cite it off my own recollection. Anyway, the judges in the Fourth Circuit Court of Appeals, they agreed with Royal's interpretation of what they consider to be an antique firearm amongst ammunition that's specifically designed for an antique firearm. Now, if a person has an antique firearm and they have the ammunition for that specific firearm, it is evident under federal law that having ammunition is not in violation of the Gun Control Act. That's what the judges said. And I'm inclined to agree with that. And then when you look at other precedent that has been upheld by the Tribunal of the Supreme Court for the United States, they also claim, and I have that here for sure, but they state that basically a gun without ammunition is useless. So if we have a right to have a gun that automatically entails that we have a right to have the ammunition that's designed to be fired from that specific firearm. And that case is found where I initially saw it in the case of Jackson versus City and County of San Francisco, citation number 746 F3D 953, Ninth Circuit, 2014. On page 967 to that specific judicial precedent, Judge Akuta, in right for the majority, stated, and I quote, "The right to possess firearms for protection implies a corresponding right to obtain the bullets necessary to use them," end quote. And of course, certiorari by the Supreme Court judges was denied in that case, which ultimately upheld that decision. And of course, Judge Akunta was quoting Ezell versus City of Chicago, where that specific case initially came out of. And Ezell versus City of Chicago, the citation number for that specific case is 651 F3D 684. And that particular quotation can be found on page 704 to that specific decision that was written by the judges in the United States Court of Appeals for the Seventh Circuit in the year of 2011. For those of you who are interested in looking that up for yourself, if you don't believe in what it is that I'm saying, but you should look it up for yourself anyway, whether you believe it or not, just to have it for your personal records. Because the more we know about law, the less likely those in civil service will be able to constantly manipulate us into believing propaganda that's totally untrue. Now, even when we look at federal statute, which is what the guy that I'm making reference to here, which is the sole basis for this particular live stream, he doesn't realize that the judges in the Supreme Court have already held many years ago that members of Congress do not have any legal authority under the Constitution to restrict our access to firearms through gun control. And that case is known as United States versus Cruikshank. And of course, there's been many other federal court judges who have utilized the Cruikshank decision to support the fact that members of Congress, to include other members of what they call the national government, which consists of the president and judges, and of course, members of Congress, do not have any authority to make gun control laws under the Constitution. But so many of us do not know that. So many of us are ignorant based upon what it is they have been implementing for so many years and actually been getting away with it. And they've been getting away with it because, like I said, so many of us civilians, we lack insight into what the law and politics is. So we go to court as grand jurors or pettit jurors during these criminal trial proceedings when people are charged with the offense of possession of a firearm by a felon in the state court systems and possession of a firearm in commerce after felony conviction in the federal court system. We go there thinking that we have no other option but to listen to the instructions that a judge give us based upon the judge's interpretation of federal statute. We don't have to do that, people. There's a such right that we have known as jury nullification. That's a right that many of us have no idea that we have. We do not know that for the most part because judges do not want to tell us that. And you have to ask yourselves, if we have an authority to disregard the law, disregard the evidence, disregard a judge's instructions that he or she gives us based upon the interpretation of the law, why would they not want us to know what our authority as individual civilians is in this country? Think, people. They don't want us to know because they don't want us to be over them. They don't want us to know that we have authority over them. Like I said, when you look at Article 21, Paragraph 3 to the Universal Declaration of Human Rights, that particular article specifically says that the will of the people shall be the basis for the authority of government. That's what it says. So, being that that article says that, that's significant, well, it signifies that we have authority over those in civil service. And of course, paragraph 2 to the Declaration of Independence lays out that foundational principle that many of us don't even know about, because many of us have not yet read the Declaration of Independence in its entirety, or at least paragraph 2, to understand what our authority is over those in civil service. We are considered the people, y'all. Judges have clarified that in various judicial decisions. Everywhere in the Constitution or Bill of Rights where we see the people, they're talking about you and I as civilians. We are the people, us. That's what that signifies. And we have to understand what that really means. We have to understand that we have authority. But anyway, getting back to what I was saying. Let me find this case just so y'all can get a good sense of what it is that I'm talking about. All right, check this out. I'm going to go ahead and cite Presser because it's quoting United States versus Cruikshank just to give you all additional legal authority based upon the same issue which I made reference to earlier. Okay, Presser versus People of the State of Illinois, citation number 116 U.S. 252, 29 LED, 615, 6 SCT 580. This case was written by the Supreme Court judges in the year of 1886. This case has never been overruled, never been overturned, so it's still what judges would consider to be good law today. On page 265 to the Presser decision, Associate Justice Woods, in writing for the majority, in quoting United States versus Cruikshank, stated, and I quote, "The Second Amendment declares that it shall not be infringed, but this, as has been seen, means no more than that it shall not be infringed by Congress," end quote. Now, if members of Congress have no authority to ratify legislation designed to impede upon the Second Amendment liberty that we have to keep and bear arms under the Bill of Rights, you have to ask yourselves, which is what I've done myself, why is it that so many individuals are currently incarcerated, imprisoned in federal penal institutions today under Title 18 United States Code Section 922 G1? That's a statutory provision that members of Congress created in violation of not only the Second Amendment to the Bill of Rights, but also Supreme Court precedent. So that signifies that members of Congress don't care about Supreme Court precedent. And unfortunately, the judges in the Supreme Court have never held members of Congress in contempt of court based upon them disregarding the very decision that they made that specifically stated that they do not have any legal authority under the Constitution to make gun laws that restrict our access to firearms through what we have grown to know as gun control. It's crazy. Now, in piggybacking off of that, Maloney versus Cuomo, citation number 554, F3D 56, Second Circuit Court of Appeals. This case was written in the year of 2009. Okay, on page 58 to the Maloney decision, in a per curiam opinion, which is a unanimous decision for those of you who did not know that. So members of the three-judge panel, all of them agree with what I'm about to read to you all now, which is associated directly with the Cruikshank decision. All right. On page 58 to that specific judicial opinion, the judges of the United States Court of Appeals for the Second Circuit stated, and I quote, "It is settled law, however, that the Second Amendment applies only to limitation upon the federal government seek to impose on this right." Let me reread that because I think I got caught up a little bit. Quote, "It is settled law, however, that the Second Amendment applies only to limitations the federal government seek to impose on this right, end quote. And of course, that particular decision was vacated by the Supreme Court judges on other grounds, not on the grounds of what the judges said with regards to those within governmental positions limiting our right under the Second Amendment to keep and bear arms. The judges upheld that. That's why they vacated it on other grounds other than what the judges said there. And of course, they were citing collected cases. The Presser decision, of which I just read, the Cruikshank decision. Then you got Fresno Rifle and Pistol Club Incorporated versus Vanderkamp. Citation number 965 F2D 723, Ninth Circuit Court of Appeals, which was written in the year of 1992 by Judge Reimer, who stated on page 729 in right for the majority that, and I quote, the Supreme Court has held that the Second Amendment constrains the actions of Congress, end quote. Now, of course, they were citing collected cases in support of the opinion that they made with regards to that specific issue. Think about it, y'all. The judges are very clear in what they claim members of Congress cannot do under the Constitution when it comes to restricting our access to firearms. Now, I know that they have created what many people would consider a loophole or an exception known as the antique firearms exception, just to butter people up, to make people believe that they have a opportunity to exercise their Second Amendment liberty. Oh, I can have an antique firearm, so they're not violating my rights. But they are violating the right, because we have to understand that we also have a right to liberty, and liberty essentially means the right to freedom of choice. So if members of Congress are saying, well, this certain group of people have a right to have this particular gun and not that particular gun, they are in essence violating one's right to liberty, which is consistent with the right to freedom of choice. And that's one thing that I learned in studying law. It's like a domino effect. Every right is its own individual domino. When you knock one down or violate a specific right, which is equivalent to knocking down one domino, it eventually knocks down the second domino, a third, fourth, fifth, sixth, until they all are knocked down. That's equivalent to law, to the rights that we have. When one right is violated, you have to understand that other rights are automatically violated also. Now, when we're talking about the right to keep and bear arms, or the prohibition of those with prior felony convictions from having certain firearms, or any firearm for that matter, based upon what many people in society feels, we have to understand that that notion does not only violate one's right to keep and bear arms under the Second Amendment, it also violates a person's right not to be subjected to acts of discrimination. It violates people's freedom not to be subjected to acts of double jeopardy. Now think about it. The only reason why a person would be charged and convicted for essentially exercising the Second Amendment under the current state of the law is because of a prior felony conviction or misdemeanor conviction. Now, if a person is going to be penalized based upon a prior felony conviction in which he or she has already been penalized for, we all know that that constitutes double jeopardy. There's no way around it. I don't give a crap what some judges in the Supreme Court say. There's no way around that, period. Point freaking blank. It violates one's right not to be subjected to acts of double jeopardy, to be penalized twice for the same offense. That's exactly what's going on when judges imprison people on account of essentially exercising their Second Amendment liberty on account of them having a prior felony or misdemeanor conviction. And it doesn't help with respecting and safeguarding those freedoms when we have members of society, other civilians, actually indicting and convicting people for essentially exercising their right to keep and bear arms under the Second Amendment. It makes no sense. And people don't realize that based upon those decisions, that is exactly why so many so-called law-abiding citizens today, speaking about the brothers and sisters in the state of Virginia, are going through what they're going through right now. That's why so many people or residents of California have gone through what they're going through right now with regards to state legislators violating the Second Amendment, which permits them the right to openly carry or conceal carry whatever firearm they choose to own. No one can sit up here and tell us what type of protection we are allowed to have to protect ourselves with. Let's be freaking realistic. Well, on the other hand, they're saying that they have the authority to have any weapon that they feel is required for their personal protection. But we have to understand also, y'all, as civilians, those in civil service here in the American government, they are going overseas and causing other people harm behind our backs. We don't know nothing about what they're doing because they claim, oh, you civilians don't need to know because it's a matter of national security. But if we are part of the nation and what they're doing can ultimately affect us like it affected many of us during the September 11, 2003 attacks, right? On the Twin Towers, Pentagon, and elsewhere, what makes them think that what they're doing behind our backs to members of other countries does not have anything to do with us? What makes them think that what they do to members of other countries has nothing to do with our safety and security as individuals or as a whole on a collective basis? Something we have to think about. I've already thought about it. That's why I don't give a crap about no gun laws. And like the brother was saying to me in one of his comments, he hoped, matter of fact, let me read it. Here's what this guy said to me, y'all, 2 hours ago, which is the basis for me responding to him, but also coming here on YouTube to conduct this live stream. He says, whatever you got to tell yourself so you can sleep. I just can't wait until you're in front of a judge and none of that you think you know about the law is actually correct and get hit with contempt charges. That's what he said to me. But in response to him, I've been in front of a judge during the concealed handgun permit hearing, and I presented the same arguments to a degree which was necessary to get my point across to the judge. And guess what the judge said in the presence of a member of the sheriff's office who was standing next to the sheriff's attorney? The judge agreed with me, dude. But you will never know that, though, because you'd rather speak on matters that you know nothing about before you investigate them. Now, if you would have reached out to me in the DM and asked me a question about it, instead of you just assuming that everything that I'm saying about the law is incorrect, which we all know that it's not, based upon the judicial decisions in which I read from you that's coming out of the court, in which you made reference to in your freaking idiotic comment to my freaking publication. Come on now, guy. You got to get real. And you are the reason. It's people like you who are the reason why we as civilians go through so much freaking unwanted trials and tribulations in this country when it comes to exercising our civil liberty to keep and bear arms under the Second Amendment to the Bill of Rights. You, people like you, who think like that. The more you think like that, the more you are going to empower those in civil service to continue to violate the Second Amendment, the very right that was designed to protect every other right. So if you don't have a right to keep and bear arms to protect yourself, that means you don't have no rights. And if you don't have no rights, what the fuck are you doing in my freaking DM telling me that you hope that I get held in contempt of court because my knowledge of law is insufficient, it's irrelevant, it has no basis in law or fact? One of the things that people like you need to realize about me, OG Chim, whoever the heck you are, is that I studied law for over 20 years, guy. Now you can look at me based upon the way I dress and assume that I don't know nothing, but I can assure you that I know a freaking lot. I've litigated cases in the court of law. Now, I never went to law school, but I've learned about law through obtaining the same resources or similar resources as law students would have in college. And during the course of me doing that, I've litigated the case or aided in the litigation of a case with an individual who goes by the name Charles Lester Van Ness, aka Midnight, from the District of Columbia, here in the United States, who was in prison for over 20 years prior to me meeting that man. And in the course of his imprisonment, he was assisted by various attorneys at law, people that went to law school. And in those 20 years, none of those freaking idiots who went to law school was able to assist that man in getting discharged. But you know who was? Me. I met that brother, took his case on once I found out about the facts of it. In under 1 year, not only was Mr. Van Ness well educated in the law to where he can speak in his own behalf if the need ever arose, but he also got discharged from prison. So where lawyers who went to law school, who charged thousands upon thousands of dollars to aid someone in their case, failed, I prevailed. So don't sit up here and tell me that I don't know nothing about the law to the extent that I tell you I do, because you have not seen it in action. Because you are ignorant of the law does not mean that the law, as I have presented it to you, does not exist, because it does. It's a problem with people like you. It's just so much. So much about law that many people are unaware of. Heck, I think I need to do a seminar on this, and that has been asked of me by many people of society that I need to do in order to educate the vast majority of Americans in such a short period of time. And I'm actually in the process of doing that. But you have to be wise, y'all. You can't keep accepting what those in civil service tell you because they tell you that. And speaking about that, let me say this before I actually end this live stream. I was telling you all about jury notification, right? How we don't have we're not responsible. We have no legal obligation to adhere to anything that the judge tells us as jurors. And you remember earlier in the live stream when I was telling you all that we have that authority, but judges don't want us to know about that authority, so many people do not know. Let me tell you this. In the case of United States versus Muse, citation number 83 F3D 672, 4th Circuit, 1996 is when that case was actually handed down by Judge Maltz, who, in right for the majority, stated on page 677 that, and I quote, although a jury is entitled to acquit on any ground, a defendant is not entitled to inform the jury that it can acquit him on grounds other than the facts and evidence, i.e., a jury has the power of nullification, but defense counsel is not entitled to urge the jury to exercise this power, end quote. Why would a judge say that? If we have the power to disregard what they say, to disregard the law as ratified by not only members of Congress, but also a state legislator within the General Assembly of whatever state we reside in, why would they not want us to know that? Clearly, they don't want us to be over them. They don't want it to be less government and more freedom. They want it to be more government and less freedom. But we have the power to change that, y'all. But we will never change that if we keep clinging to the propaganda that has been beat into our hearts and minds by lying politicians for so many freaking years. It takes a man like me to come here on social media or speak to people out in public to educate people on what the law really is. That is why I like quoting what the judges say. That's why I like quoting what the law actually says, to give you all a better understanding on what it is that you have the authority to do, or what those in civil service do not have the authority to do. Now, moving on to what I was saying about our power as jurors, and believe me, that power is vast, y'all. That power, to the extent that I'm speaking about it, is found in the case of United States versus Moreline. Citation number 417 F2D 1002, Fourth Circuit, 1969 is when that case was handed down by Judge Sobolov, who, in writing for the majority, stated on page 1006 that, and I quote, "We recognize, as appellants urge, the undisputed power of the jury to acquit, even if its verdict is contrary to the law as given by the judge and contrary to the evidence. This is a power that must exist as long as we adhere to the general verdict in criminal cases. For the courts cannot search the minds of the jurors to find the basis upon which they judge. If the jury feels that the law under which the defendant is accused is unjust, or that exigent circumstances justify the actions of the accused, or for any reason which appeals to their logical passion, the jury has the power to acquit, and the courts must abide by that decision," end quote. How much power do we have over judges, y'all, over politicians, over the attorney general, the president? That case speaks volumes. That is one of the cases that I love quoting from, because the judges are so freaking specific in what the authority that we have as jurors is in this country. And you see how they said, and courts must abide by that decision. That means judges listen to us. And if they listen to us, that means that we have power over them. It is not a government for the people, by the people, and of the people for no freaking reason. There's a reason behind that. And that is the freaking reason. That substantiates that reason. And of course, that's confirmed in Spark versus United States, which is a Supreme Court precedent. But the Supreme Court judges didn't speak as eloquently as Judge Sobolov did. That is why I like the Moreline decision, or quoting from the Moreline decision, over the Spark decision. But come on, people, I don't sit up here on social media telling you all things about law that does not exist. Everything that I speak about when it pertains to law and politics, you have to understand that I have come across what it is that I'm telling you all about, and I have legal authority to actually support it specifically, which is what I've been doing thus far during the course of this live stream. I want you all to know that you have power. It is not about police officers charging you, and I can go into how we have the right to resist unlawful arrest by using a deadly force or physical force, which is also supported by Supreme Court precedent. And for those of you who are interested in that, I believe that I have spoken about it on my Facebook live streams, and my name is the same on all platforms to make it easier for you all to find me, for those of you who are interested in what it is that I have to say. For those of you who are interested in learning more about what it is that I've said thus far, you can always reach out to me in the DM. But my thing is, don't come into the DM attacking me because you feel I lack records and knowledge of law to the extent that you have been led to believe. Because you're dead wrong, and I will confront you, because I have a right not to be subjected to arbitrary attacks upon my character and reputation. That is a right found under Article 12 to the Universal Declaration of Human Rights. So I would defend my honor and reputation from arbitrary attacks upon my person, which is what I was doing during the course of this initial live stream, which is what I'm doing now. Everything that I'm speaking about, it goes against what that particular individual, Chim underscore 420, has said about me in his comment or comments, plural, more than one. But I just wanted you all to know this. In closing, you all have to cease to put more emphasis over some statutory provision ratified by some national legislator or some state legislator over the Second Amendment to the Bill of Rights itself. Stop placing their opinions of what they feel the law is over the actual law that was designed to protect our right to keep and bear arms under the Second Amendment. Their laws does not supersede the Second Amendment to the Bill of Rights. The Bill of Rights is known as the supreme law of the land in this country. Every other law is irrelevant if it does not specifically correlate with the supreme law of the land, which essentially means, for those of you who have not yet realized this, we have a Second Amendment right to keep and bear arms. That right is known as the supreme law of the land because it was ratified under Article 6 governing the Constitution for the United States of America. So the Second Amendment to the Bill of Rights is the supreme law of the land. Everyone in America is bound by that particular document, that amendment under that specific document. So if that amendment specifically says that the right of the people to keep and bear arms shall not be infringed, and we have state legislators and national legislators infringing upon the right that's protected by the supreme law of the land, that essentially means that every legislator who has agreed to enact firearm legislation that restricts our access to arms through gun control, criminals. They're the true felons of society. They're the ones who breached the law first. The problem is there's no one in civil service who has charged them for violating the law, for violating the Second Amendment to the Bill of Rights, the supreme law of the land. They are the freaking criminals, y'all. They're the felons. It is not the individuals of society who's exercising the Second Amendment liberty to keep and bear arms under the Bill of Rights who are criminals. They're actually law-abiding citizens because they are doing what the Second Amendment to the Bill of Rights specifically says that they have the authority to do. And that is to own guns. That is to openly carry or conceal carry firearms. We don't need their permission. We don't need to pay them money to get some permit, their permission to exercise a freedom that our ancestors fought, shed tears and blood for. We don't need their permission. You all have to understand that. And anyone who would disregard one's right to keep and bear arms for whatever freaking idiotic reason that they have given thus far are in violation of the supreme law of the land, which makes them criminals or felons. But they have manipulated many of us into believing that what's right is now wrong and what was wrong is now right. And we have allowed our incompetence, our fear as people in general of them to cloud our better judgment, which has kept us in a state of being docile, of being obedient. And many of us do not even understand that. And then when you get people like me coming on social media, attempting to educate people of the rights that we have that's protected under the supreme law of the land based upon the knowledge of law that I have accrued for over 20 years. I feel it's my duty and responsibility to do this. But unfortunately, I don't have many people really listening to me, right? I don't have people subscribing to my channel like they do other people. It's like people don't find what I'm saying to be interesting. And I find that to be a problem. Because the moment things go down, the same people who don't want to believe, the same people who don't want to listen, they're the main ones who wants to seek people like my assistance after they get incarcerated, after they go through an act of police brutality. And they expect people like me to just jump at their beck and call. The fact of the matter is, I'm not doing that. I don't mind fighting for people who are unable to fight for themselves, who are too ignorant to fight for themselves. But I'm not going to step out on a limb to fight for people who have no true fight in them. That's just the fact of the matter, y'all. That's why I come on these live streams, like I said earlier. I want to educate everybody. I want people to know that we have power over those in civil service. When they step out of line, we have the power to put them back in check. We don't have the idea of separation of powers to ensure checks and balances in this country for no reason. That also applies to us. When the president doesn't check members of Congress or the judiciary, when the judiciary doesn't check members of Congress and the president, when the legislators don't check the president and the judiciary, when they step out of line, it is up to us to check them all. And how do we do that? We have two freedoms. I mentioned one earlier, the right of jury nullification. The other freedom is the right of revolution. Now, I can go more into that as well, because many people claim we don't need an AR-15 because AR-15s, they don't protect us from the government. The government has all these weapons. Well, if that's the case, why do people even care if we have an AR-15? Have people even thought about that? And some people don't even feel that the Second Amendment actually gives us that authority to overthrow those in governmental positions. They don't even believe that. Which is crazy, because that's exactly why the right was freaking issued in the first place. I just want y'all to be educated, y'all, because I know, oh, and here's the case right here, y'all. I had it right in front of me all this time. When I was talking about Royal and the right to have antique firearms and the ammunition that goes with those firearms, it was right here all along, just in my little booklet. But yeah, we definitely have a right to do that. I think it's right here. What is it? Yeah, these just cases that essentially supports the right that we have to keep and bear arms, and how those in civil service do not have the legal authority under the Constitution to impede upon those freedoms. And I appreciate all y'all for coming through. And you know, the 2 likes that I got based upon the content of this live stream. I appreciate y'all coming through. But I'm gonna leave y'all with 2 cases, right? And I do these live streams, and I'm gonna tell y'all something, which I told people on Facebook when I conducted live streams there in the past. Out of all my experience being on social media, now I come here raw. I mean, I don't do takes like a lot of other streamers do, but I understand the reason why they do that, to cut down on time, because many people don't really want to sit down and listen to a lot of things that content creators say. And I've been on here for 53 minutes and 15 seconds so far. Doesn't seem like it, but that's the reality of it. But anyway, I like to come here raw and live, because I feel that the more raw a person is, the more what a person says resonates with other people. So if it takes me an hour to get a point across that I know is going to resonate with you, hey, y'all, this seems kind of odd, right? I'm talking about law and politics, giving out the facts as the law indicates that the law truly is, and all of a sudden Wi-Fi goes out. I mean, it can be a coincidence, but it just doesn't at times feel that way. But like I was saying, I'm gonna give y'all 2 cases before I close this live stream, right? To solidify the fact that we have a right to keep and bear arms, and how nobody, whether civilian or public servant alike, has the freedom to impede upon that right. Matter of fact, I'm gonna go ahead and give you 4 cases. Okay, and I'm gonna go all in, because like I said, when I do these live streams, I do not only do them for you all, I do them to protect myself because of the things that I'm involved in. Um, I want to protect myself. I know that people tend to look at live streams and take whatever they see on the live stream and actually, in certain cases, when it comes to law enforcement personnel, they like to utilize what they see on live streams as evidence to support whatever offense that they choose to want to charge somebody with. Now, when I'm talking about the right of jury notification, when I'm informing you all, everyone for that matter, of the freedoms that we have in which they do not have the authority to infringe upon, it'll make it a heck of a lot complicated for them to do anything to me when all that I'm saying or conveying is from the judges themselves, in which they have accepted the arguments from we the people when we have brought those particular claims to the forefront of their attention through invoking the right that we have to judicial review. We have a right to have judges review our cases when we bring them to the forefront of their attention to ensure that justice is done. With that being said, let me see, which ones I'm going to give you first. Let me see, which case can I give you on first? I did say 4 cases, right? Now, you know what? Let me keep it to like 2 of the main ones, just for the sake of time. All right. During the course of my legal studies, one of the things that I knew is that we all have a right to keep and bear arms, and that right shall not be infringed. I understood what infringe meant. I understood that infringe went or applied to everyone, whether civilian or civil servant alike. And I remember coming across the case of District of Columbia versus Heller. I'm pretty sure many of you may have heard about that case. For those of you who haven't, the citation number for that case is 554 US 570 171 LED 2D 637 128 SCT 2783. This case was written by the Supreme Court judges in the year of 2008. On page 592 to that specific judicial opinion, the justices of the Supreme Court said, and I quote, "The Second Amendment codified a pre-existing right," end quote. That case substantiated that the Second Amendment liberty that we have to keep and bear arms under the Bill of Rights codified a pre-existing right. And that was substantiated in the Cruikshank decision, in which I read earlier to you all here on this live stream. Now, the judges were under the impression, and rightfully so, that the Second Amendment predated the Constitution. We were exercising the liberty to keep and bear arms well before the foundation of this country came about. And because members of Congress, the president, and judges, they get their authority under the Constitution, Chief Justice Waite in the Cruikshank decision stated that for that reason, members of Congress, to include other members of the national legislature, had no authority to infringe upon the Second Amendment liberty that we have to keep and bear arms in this country, because the Constitution doesn't authorize that freedom. That right existed before the Constitution. The Second Amendment does not rely upon the Constitution for its existence. And because they only have authority to do certain things under the Constitution, and the Second Amendment predated the Constitution, it signifies that nobody in civil service, to include any other civilian, has the authority to encroach upon our right to keep and bear arms. Now, the Second Amendment codified a pre-existing right. So when I found that out about the Second Amendment in the Heller decision, my next step was to determine, what did the judges say about members of Congress or any other civil servant for that matter infringing upon that right? Did they have a liberty under the Constitution, an authority under the Constitution to impede upon that right? And the answer to that question was found in the case of United States versus Verdugo Urquidez. Citation number 494 US 259 108 LED 2D 222 110 SCT 1056. This case was written in the year of 1990 by the Tribunal of the Supreme Court for the United States. On page 288 to that specific judicial opinion, the judges of the Supreme Court stated, and I quote, "The framers of the Bill of Rights designed the Bill of Rights to prohibit our government from infringing rights and liberties presumed to be pre-existing," end quote. You see what the judges say? You see how concise and plain that statement is, as that statement pertains to the right that we have to keep and bear arms. And of course, it pertains to other freedoms, but we're talking about the right to keep and bear arms right now. And that right, based upon what the judges in the Heller decision said, codified a pre-existing right. Now, we know that members of Congress, the president, judges, whether state or federal or national, have no authority to infringe upon rights and liberties presumed to be pre-existing. And because the Second Amendment to the Bill of Rights codified a pre-existing right, that essentially means that every act of gun control ratified by members of Congress or some state legislator is unconstitutional. Plain and simple. Two cases, y'all, eliminates every act of freaking gun control. But I guarantee you, I, for one, can personally say that I've never heard of any content creator on YouTube or elsewhere mention these two decisions to the extent that I just did. You see, I don't believe in gun control, period. I don't sit up here and say, and you will never hear me say this, man, for all citizens that legally own firearms, I never put that word before or after firearm, because the Second Amendment authorizes us to legally have firearms. So there's no need to keep putting legally own and this and that, or have a legal license to have a gun. First of all, when you look up the definition of license, a license means that somebody has permission to do something that's otherwise considered unlawful. Now, the Second Amendment right to keep and bear arms is a lawful right because the Bill of Rights is considered the supreme law of the land. For all the people who put law-abiding citizens must be able to have guns, they're essentially saying that the laws ratified by members of Congress or some state legislator supersede the Second Amendment to the Bill of Rights. And those same people have the audacity to get online talking about they are pro 2A. They support the Second Amendment. A man or woman can never fully support the Second Amendment if they are constantly talking about the laws ratified by some state or national legislator that impedes upon the Constitution when those particular statutory provisions ignore our liberty to keep and bear arms under the Second Amendment to the Bill of Rights. You can't have it both ways, y'all. It's either we have the right to have guns or we don't. That's simple. It's either everybody has the right to have them or no one has the right to have them. And that could be exactly why so many politicians are currently succeeding in this country with disarming all Americans. I say this too, y'all. I mention this, and this might get a lot of, well, people don't talk about me and my publications. But anyway, I was telling guys this, and this is something that I tell people that's getting out of prison. I had a lot of homeboys that when I mentioned these particular judicial precedents in conformity with the statutory provisions that we have supported by the Second Amendment to the Bill of Rights, which is, as you all know, the right to keep and bear arms, they tend to tell me for the most part, Okang, I'm a felon, man. I can't have a gun. I'm a convicted felon. And I tell these guys, if you have been discharged from a federal or state penal institution and you have turned away from criminal-minded behavior, every day that you're out, you are technically considered to be a law-abiding citizen. So I tell them to stop looking at themselves as if they are felons, i.e. criminals. And I got this the other day, y'all, looking at social media. When we talk about transgenderism, right? Men who claim that they identify as a woman has all of a sudden been classified as a freaking woman. And they are given the same privileges or rights as biological women have, such as they can go in the female restroom. They can do this, they can do that. They can play on female sports, stuff like that, because they identify as a woman. So everybody just must comply with their identification of themselves, even though they're technically still not biological women. Okay, so utilizing that same concept and applying it to the content that I'm speaking about here today. When a man or woman gets out of prison after they have served time for a felony or misdemeanor conviction, whether that offense of conviction is for a non-violent or violent crime, when they get discharged from prison and they say, you know what? I ain't no felon no more. I identify as a law-abiding citizen. If we're looking at that from an equal protection of the law standpoint, that means that every individual who has been discharged from prison who identifies as a law-abiding citizen must now be treated exactly as a law-abiding citizen is treated. And what does law-abiding citizens in this country currently have the right to do? They have a right to go to a freaking federal firearms license dealer, fill out that incompetent, bogus 4473 a firearm transaction record form, pass a idiotic criminal background check, and be awarded the privilege to purchase a gun of their choosing. So why, under those circumstances, are we still going the route that we're going now? Now, with that being said, I made this known the other day too. Excuse me. When brothers, to include sisters, but predominantly males, get out of prison and they continue to identify as felons or criminals, that's the way people are going to view them. Okay? People are going to view them as such. And if people view them as criminals or felons, based upon the current state of things, no one is going to want them to have a gun, right? It's just that simple. Even though they can have certain weapons. Like I was saying earlier, antique firearms are excluded from the prohibitions of the felony possession statutes, which is total bullcrap, by the way. But I'm just baffled as to why so many of you have not yet realized that. We can't allow our emotions to cloud our better judgment, y'all. We can't allow those in civil service to dictate every part of our freaking lives. When we do that, we are no longer free individuals. We are freaking slaves. Think about it. For those of you who do that, you are a slave to a freaking politician because you are too cowardly to stand up and correct them when they're wrong. I need to get my information together because I do need to conduct a live stream, but I want to do this in public and just live stream the seminar that I'm going to give on Facebook, on YouTube, TikTok, everywhere. That way I can do one performance and it can apply across all social media platforms to reach many people simultaneously. That's my plan. That's the goal that I have in mind. And I'm moving towards that goal right now as I speak. But like I said, members of Congress don't have the authority to make gun laws, y'all. They don't. And by them making gun laws that we know is in breach of the Second Amendment based upon the Supreme Court precedent that I just read, you got to ask yourself, which is what I ask myself. Okay, the Second Amendment is a pre-existing right. Those within civil service have no authority to make laws infringing upon pre-existing rights, such as the Second Amendment, which is what they have done. So I got to thinking to myself, okay, what does judges say about us disobeying those particular statutory provisions, which is where jury notification comes from? I found that in the case of Robinson versus Baldwin. Citation number 165, U.S. 275, 41 LED 715, 17 SCT 326. An opinion that was written in the year of 1897. On page 297 to the Baldwin decision, the judges of the Supreme Court said, and I quote, "No court is bound to enforce, nor is anyone legally bound to obey an act of Congress inconsistent with the Constitution," end quote. So we don't have a legal obligation to adhere to any law ratified by members of Congress or some state legislature, because you have to understand that this is a Supreme Court precedent. It applies across the entire nation. So what goes for members of Congress in this decision also goes for state legislators in every state that makes up this nation. That's just something that you all have to realize and understand. So we don't have to listen to those unconstitutional laws. And then I got to thinking, okay, if we don't listen, what does judges say should happen to us? I found that in the case of Ex parte Sibo, citation number 100, U.S. 371, 25 LED 717, a case that was written in the year of 1880. On pages 376 through 77 of that specific judicial precedent, the justices of the Supreme Court for the United States of America stated, and I quote, "An unconstitutional law is void and is as no law. An offense created by it is not a crime. And a conviction under it is not merely erroneous, but is illegal and void and cannot be a legal cause of imprisonment," end quote. Let me read that again for clarification purposes. Quote, "An unconstitutional law is void and is as no law. An offense created by it is not a crime. A conviction under it is not merely erroneous, but is illegal and void and cannot be a legal cause of imprisonment," end quote. So if we are not bound to adhere to any statutory provision created by members of Congress or a state legislator that encroaches upon the pre-existing right to keep and bear arms, and we have a right to disregard those laws, as I just stated, and we cannot be legally held accountable for refusing to obey those laws, that means that we cannot be arrested because of what the judges in the Sibo case said. It cannot be a legal cause of imprisonment. So let's say a police officer wants to arrest someone for having a gun. And we've been seeing that throughout social media. Police officer wants to take your weapon because they feel you are a convicted felon or you are in violation of the law because you're not supposed to conceal your gun or open carry in the state of Florida and all that other bull crap. Citizens having the right to say, man, up those laws. And we all know what the police are going to do, right? They're going to feel like we are disobeying their legal authority. And so many civilians believe in that bull crap. But what does a judge say, though? You know, I had to do that too. When I say do that, I had to study law and come across some judicial decisions to support what it is I'm about to say. Okay. In the case of Wright versus State of Georgia, citation number 373, U.S. 284, 10 LED 2D 34983, SCT 1240. A case that was written in the year of 1963 by Chief Justice Warren, who, in writing for the majority, stated on pages 291 through 92 that, and I quote, obviously, however, one cannot be punished for failing to obey the command of an officer if that command is itself violative of the Constitution, end quote. So all you people that say, oh, you have to obey the commands of a police officer. You have to just comply with police when they give you a command. That is totally incorrect per judicial precedent. And that goes to what I've been saying. So many of you are so freaking incompetent when it comes to law, you don't even know that you have a right to disregard what the police officers are telling you because their instructions given or so-called commands violate the very Constitution in which they took an oath to uphold and protect from enemies both foreign and domestic. But you all don't know that, so you're clinging to propaganda that's based upon ignorance to the point to where you enable those police officers to kill unarmed innocent civilians if they have grown prone to doing in recent times. You all are the freaking problem. It don't got nothing to do, oh, police officers need to be trained more. No, it is you who needs to be trained on what your rights are and what the law related to the protection of those rights are. It is up to you to gain the requisite knowledge of your rights protected by law and stand on the law as it pertains to those rights to the extent that you need to stand on them to ensure that those in civil service do not step out of line. And if they do step out of line, you need to be in that position to hold them freaking accountable. Because if you're not there to hold them accountable when no one else will, they're going to run rampant. There's never going to be any law and order. It is chaos right now. Even though we have police officers, chaos. Now, we don't have a right to listen to a police officer's instruction or commands if those commands violate the Constitution. Okay? And I got to thinking, what does the judge say should happen to us if we do not obey the commands of or instructions of a police officer? If a police officer wants to, okay, we don't obey the police officer. They're telling us to do something that we know is in violation of the Constitution or the rights that we have that's protected under the Constitution. So we resist. We decline to, you know what, I don't want to agree with you, police officer, because what you're telling me to do is in violation of my rights under the Constitution or Bill of Rights or whatever document that we choose to claim at that particular moment in time. We all know that police officers tend to get frustrated. They tend to believe that we are violating, we are usurping their authority. So, of course, they want to put their hands on us, right? They want to put their hands on us to detain us, to arrest us for obstruction of justice, failing to obey a command of a police officer. That's what they say. I've seen a lot of these content creators doing these little skits on police officer misconduct. That's what I saw. But let's see. Let's get down to the nitty gritty here. I'm basically bringing y'all to where it is that I was when I started looking at this, studying law. Okay, police officer tells you to do something, tells any one of us to do something that's violative of the Constitution, which means that what they're telling us to do is not in conformity with the Constitution or any document associated with the Constitution, such as the Bill of Rights, such as the liberty to keep and bear arms under that particular document. So they want to arrest us based upon an action that's not in violation of the Constitution. When we are exercising specific rights, we are in conformity with the Constitution. And the only time that a police officer can actually subject us to an arrest or detain us is if they have a reasonable suspicion to believe that a crime has been committed or is about to be committed. And just simply exercising one's right to keep and bear arms in public is not a crime. So they're already in the wrong. But what does the judges say about our authority when it comes to police officers subjecting us to an unlawful arrest? I found that authority to be under the case of John Baddock versus United States. Citation number 177 US 529, 44 LED 874, 20 SCT 729. A case that was written in the year 1900 by Associate Justice Peckham. On page 535 to that specific judicial decision, Judge Peckham, in writing for the majority, stated, and I quote, "If the officer had no right to arrest, the other party might resist the illegal attempt to arrest him using no more force than was absolutely necessary to repel the assault constituting the attempt to arrest," end quote. So we have the authority to employ physical or, under certain circumstances, deadly force against police officers to ensure that that law enforcement officer does not prevail in subjecting us to an unlawful arrest, which the judges have declared to be an assault upon our person. Now, what do we need in order to repel unlawful arrest being perpetrated against us by law enforcement personnel? We need to be able to exercise our civil liberty to keep and bear arms. That's just plain and freaking simple. There's no other way to put that, in spite of how gruesome that may appear to many of you here in America. You need guns. How else are you going to keep an officer, an armed police officer, who's subjecting you to an unlawful arrest, which constitutes an assault upon your person, from doing that if you do not have the tool or tools necessary to prevail in that endeavor to keep a police officer from subjecting you to an unlawful arrest? You need guns. So by them wanting to take your gun away, it puts you at a disadvantage. It puts all of us at a disadvantage because we don't know what their freaking intent is. And I get sick and tired of hearing police officers say, "Oh, we need your gun to ensure our protection and yours." Like, what the fuck are they even talking about? That doesn't make any sense. Why the fuck would I give a police officer my freaking firearm because he feels, "Oh, it's for your protection and mine"? No, mother ucker, you're the only one protected because you're the one with the freaking guns in your hand. I'm freaking naked, defenseless, in a sense. So that statement that they have concocted and been utilizing for so many years, it makes apparently no freaking sense to me at all. None whatsoever. But so many people just eat that nonsense up, though. So many people want to support police officers, even when police officers are dead wrong. Some police officers be in the right, y'all. I give them that. But it seems in the current day and age, there's more negative police officers than there are good police officers. And because the good police officers don't check the bad police officers, it makes all of them, for the most part, bad in my freaking eyes. So all that bull crap, "Oh, there's more good officers than there is bad," that's bull crap. Because if good officers, like I just said, decline to hold bad officers accountable, they are essentially conspiring with the bad acts of abusive police practices. That's something that we can't tolerate. Why would we tolerate that? Nothing wrong with a man or woman having a gun, y'all. Now, I know there's been a lot of mass shootings and so-called active shooters in this country, but doggone it, do you all not realize that the reason why those people have been able to prevail to the extent that they have is because of all these acts of gun control that many of you civilians have enabled those in civil service to create. Y'all got to be freaking real. A lot of you are the cause of the untimely demise of your own children because you supported that nonsense, and you still support it. Every time somebody gets shot, many of you want to talk, oh, we need more gun control. Let's, man, up gun control, and up you idiots who believe in that. And if you want to be technical, those of you who believe in that, who support that, you are freaking criminals. You are criminals. I mean, to be honest, and I have Supreme Court precedent to support that, because when you do that, you are violating the very laws designed to protect someone's freedom. And what happens when you get somebody that's been wrongfully convicted for something that they never did on account of the incompetent decisions that many of you people who have served on grand or pettit juries have made? What about them? And don't sit up here and tell me, oh, there's no innocent people in jail or prison. That's bullcrap. Look at the history of this freaking country, as told by those in civil service in charge of actually incarcerating people. But you all still don't get it. It doesn't matter how many people have been wrongfully convicted for something that they didn't do. You all, for the most part, you still cling to the same freaking philosophy as you had before, in knowing that you might be reincarcerating somebody for something that they never did, because you cannot separate your emotions from subjecting somebody to acts of discrimination because of how you feel. Let me tell y'all something about me. I was shot like 3.5 years ago by an unknown assailant without provocation. But do you all know that in spite of what he did to me, in spite of how I feel about what he did, that man, whoever the heck he is, still has the right to keep and bear arms under the Second Amendment? Because that right shall not be infringed. It doesn't matter what he did. It doesn't matter how I feel about what he did. He still has that freaking right. And nobody in Congress or any state legislator is going to tell me that the man doesn't have that right after what he did to me, when I'm the one who can make that determination, if anyone can make it. And then, like, when you look at United States versus Whitmire, citation number 595, F2D 1303, Fifth Circuit United States Court of Appeals, written in the year of 1979, on page 1319, to that specific judicial decision, the judges of the United States Court of Appeals for the Fifth Circuit said, and I quote, "The essence of the Bill of Rights is the protection even of wrongdoers," end quote. Now, we know that the Second Amendment liberty to keep and bear arms is up under the Bill of Rights. And according to this decision, the Bill of Rights protects even wrongdoers. And we know wrongdoers are considered people of society who violate the law through the act of committing crimes. So if a person has been convicted of a criminal offense, this particular decision signifies that that man or woman still has the right to keep and bear arms in spite of what they've done in the freaking past. But many of you don't study law. And for those of you who do, your emotions won't allow you to acknowledge what the judges in that particular case said, whereas you would like to acknowledge other opinions that judges make when those opinions benefit your position. And you wonder why there's just so much discontent amongst the judges in this country. One judge saying this about the law in California, another judge here in the state of North Carolina saying something totally different from what the judge in California said about the same freaking law that they're both supposed to be adhering to. And yet I found that every judge's decision under those circumstances is equally respected, but yet every judge cannot be freaking right when they have different opinions as to what the same law is. Then you got the case out of the Supreme Court known as Bell versus Maryland. Citation number 378 US 226, 12 LED 2D 822, 84 SCT 1814. A case that was written in the year of 1964 by Associate Justice Black, who on page 328 said, and I quote, "The worst citizen, no less than the best, is entitled to equal protection of the laws of his state and of his nation," end quote. So whatever law applies to a so-called law-abiding citizen, it also applies to a so-called convicted felon, which means that convicted felons have the right to keep and bear arms just as well as a so-called law-abiding citizen does. And I say so-called law-abiding citizens, y'all, because the Bible, for those of us who believe in it, states that every man has come short of the glory of God. Every man has sinned to come short of the glory of God, which means that we all, to some extent or another, unless we are newborn babies, criminals, to some extent or another. So that's why I think a lot of people say no man can judge me, even though that's not technically true per biblical standards. But that's probably why, or where people get that from. You have to wise up, people. Learn the freaking law. If you don't know something about law that you're interested in, reach out to me, because this is one of the things that resonates with me the most: law and politics. Because without politics, there will be no law. Without law, there will be no politics. They go hand in hand. And if we don't know nothing about politics, we are never, as individuals, going to be in a position to elect or appoint certain members of our communities to positions of public trust to represent our interests under the Constitution, to the extent that that particular or those particular interests should be represented. If we don't know nothing about law, we don't know when the laws designed to protect our freedoms are being disregarded by some civil servant in public office. And if we're unaware of that, we're never going to be in a true position to combat their abusive and negligent practices perpetrated against us through their own incompetence or just straight out refusal to adhere to the law altogether. In closing, though, learn the law, people, learn politics, and do not come on social media critiquing people about what they say unless you know for sure that what they're telling you or producing on social media is absolutely incorrect. With that being said, you all definitely, I'm going to go ahead and say, just have a good day. And for some reason, I can't even get out of this live stream. You won't end. So I don't know what's going on here, y'all.